of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. It's historic. In all of Ghana's 68-year history as an independent republic, there has never been a hearing for the removal of the Chief Justice. One would therefore have hoped that if such a process becomes necessary, it would provide good guidance and precedent for nation building. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. Was the Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that had the action for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery.
In the last hour, the embattled Chief Justice has taken legal action at the High Court, hoping to challenge the legality of the proceedings and to stop what she describes as a miscarriage of justice.
I won't resign. It's bizarre. It breaks every law. Chief Justice Araba Isaba Saki Tokono, you just heard a while ago, reiterating her points that she raised at the press conference. Unprecedented. But well, we are not in normal times, so why not? Some say. My guest this morning, Hassan Tampoli, is MP Gushon and Deputy Ranking Member, Constitutional and Legal Affairs Committee of Parliament. Musa Ahmed is Head Ahmed Legal Counsel. Senyo Hosi is Convener, One Ghana Movement. He is an economic policy person. Victoria Bright is lawyer and entrepreneur. And you may know him, may know her too well when she was advising former President Kufuor. So, ladies and gentlemen, join us. Let's begin. So we're beginning with the Chief Justice's concerns, very, very serious matters that she raises for the attention of the public, including that she has received threats on her life. She has received veiled threats to the effect that if she fails to resign or voluntarily retire, she will be made to suffer harm. Who dared do this to the Chief Justice? Anyway, that's what she's been talking about. She says the violations have not stopped from day one. They have only escalated. The choice of the Edu Lodge was chosen for the inquiry to make her feel insecure. She told the story about how her uncle, who she lived with when she was in the university, Major Aqua, whose murder, she says, the planning of the murder featured significantly or prominently in the official reports. We'll interrogate that one also. Like I told you, we are going to fact check some of the points that she raises. But let's begin right here in the studio. I'm going to take very brief comments generally from all my guests, then we come to settle on the nitty-gritty. So beginning with you, Hassan, that's the Chief Justice. Some say she's broken all the rules, broke the Constitution, but she's been forced to do so. Legitimacy just joined us. He's the CEO of the MPA and former CEO of MPA. What a coincidence! What a coincidence!
Friends right now. We should stop
the cameras here in the studio.
Discuss petroleum prices, supply, petition.
Right. And you still maintain your position as the Director of Legal of the NDC, right?
Right.
Great.
Well, you don't want to give it up?
Well, I was appointed.
You give it up and then concentrate on this.
I'm waiting for my disappointment.
Right.
Good morning.
Morning, Charlie. How are we?
Yes, sir. Yeah.
Wonderful.
Good. Good to see you. And so he was CEO of MPA. You are CEO of MPA. He took over from me as president of the SRC Law School. He took over from me as president of Ekwafu Hall.
This is incest. All right.
Okay, so I asked you a question. Yeah. Very brief, preliminary comments before we go into the substance.
Well, good morning, Samson, and good morning to your viewers and listeners. And good morning to the good and virtuous people of Gushegu, who have graciously sent me to Parliament. I think that this morning's discussion could have easily turned into a downstream conversation. Because to my right is, one of my successors at the CEO of MPA.
And then former
a very
Seaboard.
Significant player in the downstream industry.
Right.
The El Dorado of the downstream industry. My brother, Senor Hosi. So we should be talking about the Seaboard petition. I think. But, okay.
So downstream people are here to talk about impeachment.
Exactly. What an irony. Anyways, all right. So thank you. Samson, I think that the issue that has been bothering this country for some time now regarding the removal of the Chief Justice is one that should concern every well-meaning Ghanaian, whether you are political or apolitical. This is something that hasn't taken place since 1963. I believe it's about 68 years or so now. Now, it's kind of bizarre that we are going through this process and we are doing so in such a haste as to be taking some missteps. Now, this is something that is novel, never happened before. We have seen petitions against Justice Aqua, for instance. We have seen petitions against other former Chief Justices. But this has gotten to the level where none has gotten to before.
Okay, so the press are good or bad? I'm going round, we'll come back, you deal with the substance.
Okay, sure. So what it is that we must be very careful that we don't set precedent that would, take this country's democracy back many decades. So we need to be very...
So the presser was good?
So the presser, as far as I'm concerned, adds to building our democratic blocks brick by brick, to bring out issues that need to...
Thank you. I return to you. You say the presser is good. You say this is novel. We'll get to you to explain to us what you mean by novel, because it's a process for removing judges, and many judges have gone through it. So what is novel about it? Yes, Seyon.
I got into the whole party quite late. I must say I am disappointed. I find it quite unfortunate. But I do agree also that, however the case, is also an expression of the democratic principles that we all are allowed to exercise to some extent. But the act of discretion also brings the need for a lot of discretion when you hold public office cannot be lost on us. And I think there are quite some legitimate concerns around the conduct of the Chief Justice. That said, like you know me, irrespective of the matter, the merits of the conversation would still stand if legitimate.
So you have no sympathies at all. You are not sympathetic in the circumstances. Jacob Osei-Yeboah says, Samson, I was so sad when I heard her failing or falling on her sword in battle. Oh, that's what you meant. There are people who say they felt really terrible. They could hear her, sob, and it was so palpable, and they felt really bad hearing all the litany of things that she disclosed against her. Her lawyer not being heard, not being recognized, all the breaches. Instead of the rules for commissions, they are jettisoning everything. It's like a kangaroo court. Yes, Eduji, briefly, the presser, good or bad, are you sympathetic? Are you not?
Senior, once again, good morning.
Good morning.
I think the point should be made clear. Every Ghanaian, regardless of your status, has access to the press, constitutionally guaranteed. It is what you say during said press briefing that will be interrogated. That interrogation will bring the full, in fact, it will be subjected to full rigor. That, for me, is what our democracy permits. So I will not say she couldn't have organized a press this or whatever. I don't think that the purpose of the press briefing is to elicit sympathy. I don't think so. So that there will be a question as to whether someone is sympathetic to the cause. I want to find out whether the issue that she had raised relative to the current impeachment process can stand the test of rigor. It is only after that we can all come to the conclusion whether there was even merit or whether the issues raised by her have remedies known to the law.
Whether or not the issues she has raised have remedies known to the law. Of course, it does appear she points us to some of them which she has started already. So what is her crime? We'll come, Edu will explain what he means by that. Vicky Bright, thank you so very much. Yes, as a woman, let's take it from that point. What will be your preliminary comment? I've had some women advocates in the, women advocacy groups reach out to me and say right after the press conference that, oh, gee, is that what she's going through? And why is her husband not being allowed in to give her support? What's crime if that is allowed? All of that.
Thank you, Samson, and good morning to my fellow panelists and yes, of course, I'm concerned, not just as a woman, but as a Ghanaian citizen, because these are constitutional issues that affect all of us. I would have wished that she had respected the constitutional procedures or the procedures that emanate from Article 146 that have been put together, and respected the fact that these proceedings are supposed to be held in camera. And so I don't really understand, although I hear her reasons, and if they are true, of course, we will all be concerned about them, but we are only hearing from her side at the moment. And it's the whole point not to put these issues in front of these eminent people who, when you look at the panel, there are some very eminent people there, people who understand presenting your case, looking at the facts, looking at the issues, and then making decisions based on what is presented before them. So would it not have been better for her to, as someone who is a Chief Justice of this nation, to respect the Constitution and actually wait and let the hearing go through and then talk to us if she felt the need to talk to us? I mean, you said we'll examine it in detail, but my initial reaction is no, I don't think she should have gone to that extent.
Let's start right with you, Vicky. So you are saying that she failed to respect Article 146, Clause 8, which says that all proceedings in respect of the impeachment or removal of a justice of the High Court or a justice of the Superior Court or the Regional Tribunal, NCC, EC, all of those places, the process must be in camera. Have you not heard the lawyers who speak for her, including Dana Sunabadapa, Frank Davis, all of them saying that her human rights ought to trump this particular provision, secrecy provision? What do you say?
Something, look, no one is bigger than the Constitution, okay? We are all subjected to it, from the president all the way down to you and I. And it doesn't mean that it's perfect, but we cannot chop and change it as we wish or when we don't like something. This is not the first time Article 146 has been invoked. Okay, we've seen it being used against Charlotte Osei, Loretta Lamptey, and some Superior Court justices. So we are aware of how it works. I'm not saying the process is perfect, but this is what we have at the moment until we change it. Okay, and it is the first time it's used against the CJ to this extent. I mean, we had the Bright Equity petition under President Kufuor, but it didn't, because of the legality of it, because the legality was questioned by Ajaytrum, it did not proceed because the Supreme Court agreed with Mr. Ajaytrum that it was illegal. So this is the first time we've gotten this far with a Chief Justice. And as I said, for me, all these matters will come before the committee and they will give due consideration and make a decision accordingly.
She's not getting justice before the committee. That's all she's saying. She says every step of the way, every rule that she knows in justice delivery is being broken in this committee. You say she should submit herself to it and then in the end complain?
Something, we've never had Article 146 hearings done publicly. So why now? Look, Daniel Ofori, for example, if I just go through some of the specifics of what she has been saying. Under Ghanaian law, there are decided cases that Daniel Ofori as a party to the action is not obliged to testify, is he? I mean, there are lawyers in this room. He's not obliged to testify. And as far as I know, and I'm happy to be corrected if I'm wrong, no one else has been allowed to bring their spouse into these hearings. If that is not the case, then let me know. But as far as I know, so far, with the Article 146 hearings that we've had, spouses have not been allowed in.
Okay, so just hold on. Because I want us to use this platform to fact check a few things. And if you're not tuning in, tune in because I don't want you to miss today. She just said there are lawyers on this table. She wants to confirm from any of you whether the law you have studied is as certain as some say. Is a party in a case under obligation to testify? Yes, Edu.
So, Senior, once again.
Very quick, let's not. Yes. She's the one speaking now.
In the recent election petition, President John Dramani Mahama and Nana Addo Dankwa Akufo-Addo, the Electoral Commission, the Supreme Court settled the matter when there was an application to compel Madam Jane Mensah to testify the court said a party is not bound to testify. So that matter had been judicially settled.
In fact,
without
so hold on. Herself said that has she not got a human right not to testify? She herself in that ruling.
Okay, you're not a lawyer. I was asking.
But she said we all listen, we all watch it.
Hold on.
We didn't need to be lawyers.
In Re Ashalboche, the Supreme Court again settled the matter that a party is not bound to testify.
Okay.
Anybody, you can call the person to.
Thank you. She's the one still speaking. Yes, Hassan.
As far as I'm concerned, I think
here's a question. Here's a question.
I want to answer the same question.
Is a party in a matter under obligation to testify in the matter?
A party,
yes or no?
No, you have to put this in context. Because this is
yes,
Article 146.
Or say no, then you answer.
No, because we are dealing with Article 146. And Article 146(7) provides that the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. So, really and strictly speaking, this is not a court litigation. This is a committee of inquiries because the law says that shall inquire. Wait. It says shall inquire. So you are a committee set up to look at the facts.
Your answer was
then advice.
Your answer was no. A party is not under obligation. It depends,
yes,
it's not under obligation, but you are making an exception, right?
In a litigation, in a court litigation, obviously a party is not obligated.
Thank you. Hold on. But you say the general rule is that. Okay, that's the general rule. But in this case,
the party is not obligated.
Thank you. Okay. So let's go to Vicky back. All right, let's hear you continue with your submission.
The woman.
Yes. So I agree with what all the lawyers have said clearly, because that was my assertion that Daniel Ofori, is not obliged to testify. The decided cases have been mentioned. The recent one on the election petition, Nyami versus Ansai, then Ria Saripoche, etc. So for me, that is now decided. That's decided law as far as I'm concerned.
The question that springs from that, and I'd like my viewers to come along with me, let's learn. Sometimes it's important. You just can't, do anything around that. Is the litigation kind of cases and precedents you are using to support what she claims the commission is doing, the committee is doing, is it the same as an inquiry?
Well, the law is the law, Samson. We cannot operate, the law in silos. That is what the law is. And in a commission of inquiry, I think there's also the same Ajay Chun before Justice Sophia Akufo said that they are allowed to make their own rules, right? It's an ad hoc, and they are allowed to make their own rules. I don't think that we can operate in a vacuum. With this Article 146. So I'm using these examples to buttress the fact that, Daniel Ofori, just as Jane Mensah was not obliged to testify, he is also not obliged to testify before the committee. His petition, I believe, is before the committee, right? And also, what our understanding is that the Chief Justice got details of it from the President when she requested for it. So she also knows what it says. In fact, it's all over the news now, what all these petitions contain. So that is my that is my starting point in all of this. The threats that she's talking to are obviously very serious.
Right. Vicky, hold on briefly for me, and forgive me, but I'd like us to do it this way a bit. Tied to this matter of the excusing the petitioners from getting into the box and she also cross-examining them rather than they calling witnesses and not showing face. Tied to that is what she speaks about as the conduct of the proceedings in a typical adversarial litigation manner, contrary to procedures of a committee or commission of inquiry. I read her. It is important to state that even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, we have on the statute books of Ghana a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commission of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467, if a committee is set up for the removal of a chief justice, the committee is supposed to inquire into the petition, the answer and the prima facie case. In spite of this, on the 15th of May, the committee indicated that it will conduct the hearing not as an inquiry, as directed by Article 1467, but as a regular litigation. The committee rejected the use of CI 65, which is created for the conduct of an inquiry, and stated that they will rather use the High Court Civil Procedure Rules 2004 CI 47. What do you say? She says this is wrong. They are supposed to use the commission or committee of inquiry, rules rather than CI 47.
The difficulty she has is that we have to work with what Article 146 says, and the interpretations that have been given by the Supreme Court of Article 146 and the committees emanating from Article 146 when prima facie cases are established. Okay, and as I was saying earlier, in the same Judicial case that we've been talking about, Justice Sophia Akufo at the time held that a committee formed under Article 146 is an ad hoc committee and is free to determine its own rules. So if it is deciding that it wants to go in a certain direction, then, then they are allowed to do so. Now, it doesn't mean that we are happy about what they decide or what they don't decide. And I started off my submission by saying that we may not be happy with every article under the Constitution. We all know it's a living document, right? And laws in it. And this is why, from time to time, various presidents set up committees of inquiry to look into.
The question that comes up, Vicky, is that you are referring to a Judicial, where the Supreme Court said the committee can make its own rules. That was in 2005, 2006. But the rules that she's referring to, CI 65, was made in 2010. Shouldn't the rules specifically made override the court's decision?
Something, the law, we have various types of laws, right? And they all are supposed to work in tandem with each other unless they are specifically repealed. So unless something is specifically repealed, or in a case of a decision by the court, unless it's reversed, in this case by the Supreme Court, since they are the sole interpreter of what these constitutional provisions mean, we have to go with it. Mm-hmm. Of course, I respect the fact that we all have human rights and these human rights should be respected. I'm sure that if you speak to Charlotte Osei and Loretta Lamte and all those Superior Court judges who were removed, they would have the same sentiments that they felt that their human rights were not respected. So the point I'm making is that we should stick to what Article 146 says. We need to stick with that. And if we are not happy with the way it operates, and we all have seen the flaws in the operation of this particular article, then we need to put it before. Luckily, we have a Constitution Review Committee going on now. We need to place it before the committee so that they'll look into it in more detail and fix the gaps in its operation.
All right.
But what you cannot do is chop and change things to suit your situation. And also this interpretation. I mean, has this whole thing not been put in the bosom of the President of the Republic acting in conjunction with the Council of States? I mean, why is one person, I know she's the Chief Justice, she's a Justice of the Supreme Court, but while it's not subject to one person's interpretation, we have to respect that this is not, this has been put into the bosom of someone else, not her. So you can't come So, and make your own rules just because what is there does not suit you.
Okay, I think I will have you also comment on this part. Then I come to Hassan Tampoli, who has a divergent view to these circumstances. She says her lawyer, and this is not the first time, she's just repeating it to us, that the very first time the committee sat, her lawyer appeared and her lawyer was not recognized in her absence. She says this breaks every rule she knows. What do you say?
Well, I believe her lawyer should have been recognized. I mean, I think that if someone has representation and that representation has been made known to the committee of inquiry, the court, whatever it is, the person's lawyer should be recognized. There are situations where this is difficult. I mean, we have this kind of Koreata thing going on, for example, but I think that if someone has legal representation, it's important that the legal representation, the legal representative of the person is recognized. And if the person's presence is required by the committee, then they should make that clear that, we need your client in next time.
The committee will definitely not speak because of the injunction in Article 146, Clause 8. But I'm beginning to read into their minds. Do you think that the reason on that day they refused to recognize the lawyer was like a typical inquisition? If an accused person was brought before a court, there were charges brought before a court that the accused person does not appear, and a lawyer showed up to tell the court that I represent the accused person. Do you think the judges are entitled to ask a question? Do you really have the capacity to represent the accused person?
Well, you don't in a court situation because, of course, the accused person must present themselves for the trial. This is a commission of inquiry, and so they can decide how they want this to be conducted. But it's also not realistic to expect that a whole inquiry can be made on your behalf without you being present. I mean, you have to be there, so that questions that the legitimate questions that the committee has can actually be put before you. The lawyer is not privy to every single aspect of some of these things. So there may be certain types of information which are solely in your knowledge.
Okay, thank you. Let me come to Hassan now. So Hassan, 3 issues she has spoken to. I brought you in briefly, and I need you to tell us what you think. Beginning with the CJ's very first issue, the non-recognition of her lawyer in her absence. Would you go into the mind of the committee and think they were thinking, what if we recognize this lawyer and later she shows up and says, that is not my lawyer? What would they do?
Well, Samson, before I go into all of this, we need to take our minds back to the period during the electionary campaign. Some political comments were made.
You see, she did it step by step. We are going to do it that way. Hold on. Just hold on. Help us do it this way and in a healthy manner.
But Samson, you have to allow me to build my...
The CJ, no, wait. The CJ listed about, I think they're about 6.
I will deal with them.
Wait. The way she listed them,
yes.
She even brought in the question of politics and all.
That's right.
So I want you, if you don't mind, let me moderate it this way. Vicky has answered to 3 of the issues she raised. I want you to respond to those 3 issues, whether you hold a different view, beginning with the non-recognition of her lawyer in her absence.
You see, so the points, so I'm sure I'll still get the opportunity to...
Of course.
But the essential matter is that every person appearing before a committee of inquiry, a panel, an administrative panel, a court, is entitled to have a counsel of his or her own.
That's right.
All right? And that is constitutionally guaranteed. And in the absence of the person, the lawyer should be given a hearing. any attempt not to allow the lawyer is an attempt to deny the person. Because it says that if I am not available, this is the person who is my proxy, who is my agent. In the event that he's not able to respond to some issues and I need to be there, then I'll be there.
Remember, this is in context. Let's put it in context. Is that this is the first meeting.
That is the first meeting. Yeah.
And the lawyer shows up and she is absent. Will it be the same?
I think that, you see, you have to admit and then accept the person on record, at the very least, because I have announced myself that I'm the lawyer on record. You will send counsel to court, and then on some occasions, a different lawyer comes in. In fact, in some instances, somebody completely different becomes, a friend of the court or comes to the aid of the accused persons or even parties in court. We do that all the time, all right? But in this particular instance, the person is not the meddlesome interloper. He has been properly, instructed to represent the Chief Justice, and the person is there. So I think that it was wrong for the committee not to have given the lawyer audience.
Great.
And insisted that
the next point about about going public in breach of Article 146 Clause 8. The argument is that her human rights trumps Article 146 Clause 8. Do you agree?
You see something. What Article 146.8 does is to say that even if a person appears before a committee set up under Article 146, you can't come out and say anything about it. You are enjoined to remain quiet. But if you read further to Article 1469, it says that the president shall in each case act in accordance with the recommendation of the committee. So I do not have any right in between. And when the inquiry is over, I do not have any right again. So at what stage does the Chief Justice have a right to raise questions about the conduct of the committee? Now, let's look at it from this perspective.
Let me read it so that you continue. It says, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other aspect of his choice.
Exactly. Now, something, the law that we have studied, there's an equitable maxim that equity will not suffer a wrong without a remedy. So if there is something going wrong on Article 148, where does she go to?
She says it's actually breach of natural justice.
Exactly. Where does she go to?
Go to the courts.
She went to the courts.
Yes.
And then she was thrown out.
Yeah, it means that you didn't have a case.
So where does she go to? No, the court said that by
the public is not the place.
No. The court is saying that by reason of Article 146.8 confidentiality clause, you can't even come to us.
So they expunged.
So even they expunged the supplementary affidavit that she swore to. They expunged all of that from
because it contained matters that ought to be in
emanated. So at what stage would the person have a right? And now don't forget that this is an administrative process. So a panel set up under this constitution ordinarily should be guided by rules of natural justice, which are fundamental. First of all, the issues of prima facie. The 3 petitions from Daniel Ofori, from Ayamga, and from Shining Star, they contain a cocktail of allegations. Now, we all know by reason of Article 127, Article 1273, and for the benefit of readers, I just want to read it. It says that a justice of a superior court or any person exercising judicial power shall not be liable to any action or suit.
But we are doing a merit review.
Oh, please.
Is that what you are doing?
Please. Allow me to
I just
or suit for any act.
I didn't want to stop him. Let him finish.
Or any act or omission by him in the exercise of judicial power. So when you receive the petitions, one would have thought that in the submitting of notice that a prima facie case has been established, it should have been accompanied by particulars of what constitutes the prima facie case. Because we know that this is a complete immunity. So any part of the petition that sins or contaminates Article 127 should be disaggregated immediately. And then things that they think would fall under Article 146, stated misbehavior, or if they think that she is not fit and proper to be in there, then she should be told.
Okay.
But what we are giving to is that, and what is public right now is that the Chief Justice has been asked to respond to virtually everything.
Okay. Now go to this point. Let me. We are going around. Hold on.
I just want to make a quick point before.
Because you are going to different issues now.
No. It's the same issue.
Okay.
Don't forget that the committee says that they are going to use CI 47. All right. Now, you and I know when issues, you are done with pleadings, application for direction, you set down the issues, isn't it?
That's right.
Exactly. So what are the issues before this administrative panel? The accused person, in this case, the Chief Justice, does not know exactly the gravamen of the petition that she's supposed to be responding to, as far as if the prima facie case has been made. What exactly am I responding to? Because you need to take out issues that sin against Article 127, put them aside, like Daniel Efori's cases. All right, she sat on some of the matters with Justice Prima, for instance. That is issue number one, and that is the right, to be protected under Article 127.
That's part of where she's saying that the CI 65 should be used.
Should have been used, and then I'm coming to that point again. You see, so a decision has been made by the committee. We all know that a committee of inquiry is entitled to set up their own rules. But this is not a committee that is set up by a constitutional instrument. It's a constitutional, it's a body that is created by the Constitution itself. So I'm not too sure whether we need to set up a CI to be able to establish it. That being that as is may. Now, this particular committee, I'm not too sure whether the chairperson, Justice Prima, should have been chairing it, for instance.
Okay, now hold on.
Now, the Nemo Judas in Kausaswa.
No, hold on. I want us to do something on this platform, and I need you to help us.
Very well.
You see, there are other angles. We will be left on your own very soon to go into the way you want to.
You unleash us.
But because we are educating... So you have hold on. Because you have dealt with the third point already. Because we are educating the public, right. She has raised specific issues. So we want you to help educate the public on these specific issues. Thank you.
Maybe just
Thank you very much.
Because you see, like you raised out, there are specific issues that she had raised. If you look at CI 65,
correct.
CI 65, which obviously Parliament conceded, has Regulation 2021. 20 has the heading, application and scope. And it is clear. Let me see.
Let me read it.
Okay, let me just help me out so that I'll build.
Okay.
Application of rules.
I brought this copy here to show all of you to read, to guide the people.
Regulation 21, quote, a commission may deviate from the application of a provision of these rules where, in the opinion of the members of the commission, strict adherence to the provision is not compatible with or is not essential to the performance of the function of the committee. Now, if you come to 21, what it describes as, what's the name? Interpretation session is clear. Now, even before that, it says, subject to these rules, the High Court Civil Procedure Rules shall apply to the provisions of a commission with the modifications that are necessary for the effective performance of the function. So, with respect, Her Ladyship, the Chief Justice, possibly if she had adverted her minds to the express provision relative to this particular, what do you call it? CI, will not have made the point that she made. Because even with CI 65, for a commission of inquiry, it is limited. Even more importantly, the powers of the commission. Now, if you look, because commissions of inquiry, practice and procedural rules 2010, CI 65. And he says, quote, in the exercise of the powers conferred on the Rules of Court Committee by Clause 2 of Article 281 of the Constitution, these rules are hereby made. So specific for commissions of inquiry. The commissions of inquiry.
Hold on, please. Says there are commissions of inquiry.
No.
Also,
let's draw the
committees of inquiry.
Let's draw this.
Commissions are committees, depending on what they call them.
Leadership of Akufo in Ajechum clarified the issues and said the commission or the committee made pursuant to Article 146 is an ad hoc committee. It is not that committee envisaged by reasons of commissions of inquiry. So I think it's important that we draw the distinction and to make the point that CI 65 is completely inapplicable. What is the precedent? When Nanado Dankwa Akufo-Addo, when the process for the removal of Charlotte Osei and the late Amadou Sule, when they first went for the meeting of the committee, chaired by His Lordship Justice Anthony Bennett, it was at the first hearing by way of precedent that His Lordship Justice Bennett, Agnes Doji, and the late Justice Mafo Sao and now inquire from the lawyers, including my senior Tadiosori and co, what rules and procedures should be adopted to regulate that Article 146 proceeding, contrary to what CI 65 provided. So, Senior, with respect, let's put the matters in context. And if you put it in context, you will notice that under Nanado Dankwa Akufo-Addo for Charlotte Osei, it was the committee that set up its rules, by which time CI 65 was already in existence. It was never applied. So why are we saying that the rules should be different? Because it is Justice Gertrude Toko.
You just read. Hold on. I think we have to make the education abundant for our people so they will make the judgment for themselves. You just read section Regulation 20. Regulation 20, I want to read it again. It says, a commission may deviate from the application of a provision of these rules, where in the opinion of the members of the commission, strict adherence to the provision is not compatible with or is not essential to the performance of the functions of the commission. Subject to these rules, the High Court Civil Procedure Rules 2004, CI 47 shall apply to the proceedings of a commission with the modifications that are necessary for the effective performance of the functions of the commission. I won't interpret what this means. I just read and leave it there.
Can you take it again?
It says that sub-regulation 2, subject to these rules, the High Court Civil Procedure Rules 2004, CI 47, shall apply to the proceedings of a commission with the modifications that are necessary for the effective performance of the functions of the commission. So answer whether the committee, if they decided that they are even using CI 65, whether they are entitled to use CI 65 or they are entitled to use CI 47, which we are told is what they say they want to use. Now, we need to read 21 as part of the education. Regulation 21 says, in these rules, unless the context otherwise requires, chairperson includes a sole commissioner appointed under Clause 2 of Article 278 of the Constitution. Hassan?
Yes.
Article 278 is not Article 146. Now, here again, it says commission means a commission appointed under Clause 1 of Article 278 of this Constitution, not under Article 146.
Yeah.
Go on.
I think I've made that.
Just education.
No, so just what it means is that CI 65 relates to a commission appointed under Article 278. Nothing more, nothing else. Question. The Poimand-led committee, is it a committee appointed under Article 278? No.
You see,
Now, the second issue, which was the first, not recognizing his lawyer.
Okay, so that I can deal with that issue quickly. The first day, the lawyer that appeared for her was Kwabna Kusi. So when Kwabna appeared, the committee members had no idea that this is your name lawyer because she herself had not come yet. But subsequently, she had been appearing with my senior Ayuko Otu, and the committee had recognized as such. So
was it fair?
Yes.
That a lawyer comes to say, I represent the Chief Justice. Please, no mean person. Chief Justice. And then you say, we won't recognize you because she's not here to confirm that you are actually his lawyer, her lawyer.
No, senior, with respect.
I'm coming to you. Hold on.
You see,
hold on.
There's a recent Supreme Court decision on this.
Legal representation.
This Supreme Court.
Oh, please, senior. There's a legal representation for no mean a person like the suspended CJ. At least for the record. You notice that for our cases in court, the plaintiffs are first named before legal representation. The reasoning is simple, so that the plaintiff or the party or its representative can actually confirm whether it is you who has been authorized to represent the person or not. At the material moment, that information, in fact, he had gone to make an inquiry because just around that time, there were filing processes at the court just to make an inquiry for an adjournment. Then the court said, who are you? I mean, and subsequently, with respect, senior, the substantive matter led by my senior Ayiko Otu, the committee had given her all the privileges.
What do you say?
Isolate that?
What do you say to the question that giving the press conference?
But he knows everything.
What do you say?
Who brought it up?
So I'm coming to you right now. What do you say to the defense by, as I mentioned, people like Frank Davis and Dana Sonaba Dapa, that her rights, human rights, trumps Article 146 Clause 8, even though 146 Clause 8 says the proceedings must be confidential, in secret. When her human rights are violated, she's allowed to come to the public and talk to them.
Which right are they asserting? Which right of hers are they asserting? First of all, she makes a proposition much earlier that, for instance, she has a right to even waive the constitutional in-camera hearing. First of all, the constitutional provision is imperative, mandatory. It's a SHA. When SHA is used, how do you waive it? There's no waiver.
You are doing it to protect her, and she says, I don't need it. Let the public follow the process.
The framers of the Constitution didn't envisage that for her. And I'll tell you this. If you recall, the Ghana Bar Association in 1995, wanting to circumvent this constitutional provision,
93, 95.
Yeah, 93, 90, sorry. Decided to use a writ action to circumvent this constitutional provision by putting in their pleadings the grounds for removal of Aban. Look at the manner in which Justice Pega and Ajabe said, first of all, an association of lawyers, the creme de la creme of our society, should know better and not invite the court to engage in obvious illegality. Most importantly, His Lordship Justice Pega had these words. He said, look, the in-camera proceedings is to preserve the judiciary itself. Because imagine a situation where you bring cameramen to come and video the proceedings, and it turns out that the person is not guilty, as in the pleadings. However, you know what lawyers do under cross-examination? They can mischievously ask a question, knowing that the question will be disallowed, by which time they are poisoning the minds of people. All these antics are deployed in proceedings that are aired. So to protect the sanctity, have it in camera. The framers of the Constitution didn't put this provision because of one person.
Her point is that
it's to safeguard all
her point is that if the issues are matters so serious about national security and so on, then you can keep it secret. But this one, she has looked at the petitions, and these are just frivolous stuff. So let the whole world enjoy it.
Senior, hold on. Senior, I beg you. No, Senior, let me
wait. It is Senyor's turn. I'm coming to Senyor after him.
So, Senior, if you look in Article 146, the wording used, it says shall, without exception. It didn't say when the matters for the removal or the grounds borders on national security, have it in camera. No exception. Where is she creating those exceptions from? Look,
but you apply reasonable mind to it. The Constitution may not have to say it.
You see,
but reasonably we can tell that if the matter is not any serious matter, why should we do it in camera?
One provision that has received enormous judicial pronouncement is Article 146. The ins and outs of it all have been litigated in our courts.
No.
Please.
146, it has not been really litigated like
the
that.
nature of the issue that she raises.
Yes.
First of all, Ajechum resolved the matter. Plain. Much earlier, 25 years ago, the Supreme Court in Ghana Bar Association and Attorney General resolved the matter. Ajechum did. And all the subsequent decisions, Derry also did the same thing. So the whole idea that new set of rules...
Can't we have a departure?
Exactly.
Because it's not serving as well.
But you see,
what is not serving as well?
No.
The HKC Preemptive Committee is still working. My senior here, he's even had another platform, Parliament. They will be meeting members of Parliament. We can approach the senior Professor HKC Preemptive Committee and say, look, having tried this Article 146 provision for 32 years, we are tired of it. Amend it. Said that proceedings involving superior court judges should be held in camera. But you see, Justice Pegan said something, which I think it goes beyond today. He said, look, can you imagine a day when justices of the superior courts, their removal processes is being telecasted? It goes against good conscience. Timeless words. Timeless. So where from this invitation?
If you have done wrong, let the whole world know it.
You see,
what about if you have not? And I just
let the whole world know it again.
Because the process can exonerate you.
Yes.
Okay. Now hold on, all of you, hold on quietly, please.
For starters, I don't even know. I don't know what business.
I'm not holding you to anything. So let's hear you. Let's hear you in the next few minutes.
Equity.
No.
Three of them are sharing a certain position.
Hold on.
But you see, definitely from the discussion, I need to be able to
Thank you.
So
just hold on. Otherwise, Senyor has not been heard. Let's hear him.
I don't know what these lawyers who refuse to join the whole process of writing this constitution have. It was carpenters and businessmen like me who wrote this constitution. When we are talking, we should keep quiet. I can't talk. Samson, you are asking the question about the human rights. Are you going to adjudicate your rights or enforce it in public through a press conference? I don't see how.
She says she has filed a human rights case.
I should file it and go and deal with it at that case. The only point at which that gets materiality and impact and effect is in court. So I don't know what this entire thing was about. This attempt to prosecute the matter or adjudicate the matter in the court of public opinion is rather an act of indiscretion and unfortunate.
Is it because it is her? Are there not cases that are in court that we discuss all the time here?
It is because it is her. And not her in her person, but her office or the office she held for which she's actually being held accountable. You are Chief Justice. You should understand the law much better than anybody, not relatively, but you should understand the basics of it. The provisions about this being in camera are very express. They are not ambiguous, where you can't understand the impact and the relevance of it. Your human rights must be protected at all times. The Constitution actually requires that that is done by everybody. So you being able to enforce that or demand its enforcement is right. But we also make an assumption in the conversation that human rights have really been violated. And I take her own speech, and let's go through them. You mentioned them 6, right? These violations, she talks first of all about her counsel. Me, I don't even understand why out of policy courtesy, for the office that you hold, your first hearing, you refuse to be there. I don't know her reasons. If you refuse to be there, you should be able to formally notify the commission or the body that is the inquisitorial body that's looking into this matter who your representation is. You don't, and somebody just shows up and you expect them to necessarily just admit them and assume that that person necessarily represents you. And you are Chief Justice. Remember that. You are just a suspended Chief Justice. We currently have an acting Chief Justice, but she is still Chief Justice. Again, it is unfortunate when she tries to paint the picture that this entire inquisitorial body has been that adversarial on the account of this. In her own submissions, she admits that her lawyer was allowed to stay, the purported lawyer was allowed to sit present. I think that the court had every single committee. The committee had every single reason to dismiss the person from the entire process because it's supposed to be in camera. We don't know your locus here. And if this is supposed to be in camera and private, why do we entertain you here?
The fact that you entertain him and refuse to recognize him, does it not defeat the purpose of not recognizing him?
Let me give you some information. Let me give you some information.
No, your time.
I'm giving you some information. I'm giving you a piece of information that will guide you.
Let him give the information.
This same lawyer who was not recognized had exchanged correspondence with the committee. And they have even served him hearing notice for that sitting that day. So how can the same person come before you? You say you don't recognize him. You have exchanged correspondence with him. You have served him. Please.
Senior Hassan. Please. Was did the committee subsequently allow Kusi?
No, but I'm saying
yes,
that.
He did. Even subsequently, after the initial this thing, he subsequently
did you know this information?
To them.
Did you have this information?
Yes, subsequently he did.
But I'm saying that they had exchanged correspondence with him, so he was not a stranger to that place.
No, but I'm saying
and they served him,
notwithstanding the initial
hearing notice,
the initial consent by the.
So he was there because the committee had
invited him.
Wait.
And the person comes, you say you don't recognize him.
Wait.
Because your principal
Hassan,
is not present.
Hassan, please pay attention to me. So they issued a hearing notice.
Yes.
To the respondent or to the lawyer for the respondent?
The respondent.
Wait.
You see, the committee has served hearing notice on the counsel before the hearing.
So let's be clear about it.
Yes.
Do we know for a fact that the committee would issue a hearing notice for their first sitting on a lawyer rather than the respondent?
You see, prior to the hearing notice, there had been correspondence.
Okay.
So there have been some established relationship, and they know for their records that this is counsel to the Chief Justice. You know, and then by reason of that, they served him hearing notice.
Okay.
How does a person
Thank you. Point made.
So please modify.
I don't agree. No, he's not modifying. I'm not modifying that. The facts.
This is his turn. Let him speak.
That's a narrative. That's a narrative he's bringing. None of
you doubt me?
It's not that you also
no. But subsequently, even the committee members allowed the lawyer to speak.
I'm taking the woman's own words.
No. We are dealing with the first.
Can I finish?
Yes, the first meeting he spoke.
Can I finish?
You were subsequently.
Gentlemen, can we allow?
Please.
I cannot speak to the fact as to whether there was correspondence or not. That it doesn't make sense to me that at your first meeting you've not brought your lawyer. You yourself you don't attend, and you just expect absolute cases being extended to you in that fashion. I don't think it was proper. I think it was quite irresponsible on the part of Tokono. No, it was irresponsible. It was irresponsible. I agree. I don't have any apologies for that. No, that's your opinion. I don't. I'm not moderating anything. I'm not. I think that it was irresponsible on her part. She should set the right standard.
Please, let's not.
I'm sorry. I'm not you. I am not denigrating.
Moderate, please.
Hassan, the fact that you even agree that even me sitting here and saying that her conduct was irresponsible. Her conduct of not formally introducing her counsel is irresponsible. That is what should tell you the consensus you should be having around the in-camera proceedings.
To the effect that you may not have the full facts.
Yes.
Really?
Even though some may say, if this is how it happened as Hassan is putting it, then it should have been part of her statement. But you may not know what may have happened. So to say that she was irresponsible on the part. Don't repeat that, please. Don't.
No, I'm coming. No, please.
Don't repeat
I have no apologies. I have no withdrawals on it. I repeat, I'm relying on her submissions. If she had formally introduced that lawyer, she would have said it. And she should have said it. And if she also didn't inform us, that again is inappropriate on her part. You don't share information in a certain fashion to try and shape public opinion without being pure about your submissions as well.
Can you move on from that point?
Yes, I'll move on. So I don't see the point. Again, let's go forward. Do we have a situation where her lawyers have not been granted hearing in the process? Subsequent to that, there's no evidence anywhere. And it's a very unfortunate situation because you've put the entire committee in a boxing ring and you tie their hands. And you alone are throwing punches. I repeat, it is irresponsible. The fact that you have the right to speak does not necessarily mean, just like I said the last time when I was here, that while the Bible in 1 Corinthians 10, 23 or so, while all things are permissible, not all things are beneficial nor constructive. When you hold a certain position in society, there's a certain level of discretion that is expected of you. She hasn't exercised it right. Go to the next one. The committee failure
level
to
of
indicate
discretion to be exercised by somebody because she holds a high position. That person has come under threat of harm if she doesn't resign. That person is pointing to you that even within the public domain, you are all been pointing to this is like a hatchet job. It's been planned long before now. That person says, you are taking me to a venue where my uncle, when I was in school, who was taking care of me, there was a plan to murder my uncle, and the planning happened at this place.
And I was there.
And you are traumatizing me. Hold on. In this circumstance, I want to come into this place with my husband to give me some support. You would deny my husband the opportunity. You search my bag. CJ, you said she's still CJ.
CJ?
Her bag, handbag. Yeah. Why?
Okay, no, let me finish. So you allow me to continue. Now, you talk about a committee failure to indicate the specific allegations in respect of which a prima facie case has been established, as well as the reasons for same, to enable me to determine my legal rights or adequately prepare a defense to the charges against me. I'm very concerned about this. On the face of it, I said, okay, if there was a merit in any of these charges, she should know exactly which one she is answering. But then I asked myself again, who did the prima facie? It was the Council of State and His Excellency the President. Then you set up a committee. Are you now going to take your reasoning and put that before this committee to prejudice their own assessment and evaluation of the process? That creates a legitimate concern. I think that if the prima facie has been done by a different body, and not that same court or that same body is going to actually sit on the case, the new group must be allowed to freely act. We'll be the same people at this table trying to suggest that His Excellency the President and the Council of State were trying to shepherd the thoughts of this entire committee, which is supposed to do an independent job, independent of the thoughts.
Please,
of
her question is this. This is her concern. This is her concern. She goes to the committee. She says, where's the petition? They say, we won't give you. We know that President has given you.
That's not what I'm reading. Please, I don't want you to make.
No. Hold on. Please let me do this.
Yeah.
She gave her response together with evidence. She says, I want to see what you have because I'm before you. They say, we know you give it. So what? She's saying that after the prima facie was done, let's say there were 100 complaints. The prima facie may have dismissed 10 or 50. So tell me that these are the 50 left again. And that is what we are brought here to answer. But don't tell me to come and do the whole thing. That's a problem. You don't understand that.
Hear me, Samson. I'm saying one thing, you are saying a different thing, but I'll answer yours. But let me finish mine. I'm talking about the prima facie. She being privy to the reasons why it was established, I think to be prejudicial to the activities of the committee. If the two of you have taken a decision, you've evaluated something, and I'm supposed to independently look at it, I should hear the case freely. I shouldn't now be guided by your own decisions, which should not influence mine. I have a problem with that. Now, to your particular question, I agree with you. I heard there very clearly when she said she cannot confirm whether what she has is exactly what the committee has. You are dealing in the space of politics. She has every reason to be concerned, and I support her fully. I don't think that if that is true, the conduct of the committee is necessarily optimal. But unfortunately, we are again fighting a committee in a boxing ring with their hands tied to their back. Number 3, she says that the committee did to permit 2 of the petitioners not to testify to enable me cross-examine them on their petitions. I think that matter has been flogged. So I take these first 3 things. I don't see where the human rights matter as we speak. As the process continues, I don't see where the human rights matter is. Number 4, a denial of an opportunity to be in the hearing room with my husband or a close family member. This is an in-camera process. It is clearly defined as an in-camera process.
And the 2 shall be one.
The 2 shall not be one in court. That's why when I am held guilty on something, my wife won't follow me into prison. If she goes, I will walk her to the place. I'll cry for her. I'll defend her, do anything, but I cannot replace her in prison. It will never happen.
Small courtesy. Can't we make a little exception of the rule?
I mean, if the committee wants to do that, the first thing is, would they be in breach of 1468? I think that will be an absolute breach of 1468. That is in mind.
Casey demands a breach of the Constitution.
You cannot do that.
The understanding?
You see, that's why I actually have a problem with the committee.
No, Senior, is that the understanding?
No, I'm going. I have a problem with the committee.
Senior Hanson.
Hold on. I have a problem with the committee.
Is it there's a fundamental misunderstanding of this in camera hearing?
Allow me to do my thing.
Say you will finish his submission soon. Please allow him. Right.
I have a problem with the committee, especially on the very first issue she raised. If you did not recognize the lawyer, why did you keep the lawyer there?
Oh, I thought you had moved on from
that. It comes back to the in-camera matter that I was trying to cite, all right? But in this process, you have to draw the Chinese walls. You are not here in your person. You are here because of an office, a public office you held. That's supposed to be protected. We must realize that there's a value in that process. The process of this in-camera structure is not designed just to protect Tokonu.
Why not?
It is designed to protect the entire process, including the petitioners, including those who are also sitting on the case, for clarity and objectivity in their decision making. When you have cameras on you, there's a conduct, there's a way you do your things. Because you are now evaluating judgment by a public. This matter is too sensitive because we are dealing with a group of people whose office we deliberately and willfully protect for our own good as a country. So if they are supposed to be shifted, we must also maintain the dignity and honor of that office. That is a decision that we carpenters and businessmen, not you lawyers, decided to sit down and draft in our constitution.
Okay.
We are not inside. The last one. I have to finish. Yeah.
He's not going to forgive the lawyers for boycotting the process.
He's so upset with the lawyers.
No, these people, they refuse to. They have to come and apologize before we forgive people. The last one, the sixth one. The conduct of the hearings in a condoned high security zone. Right. Listen, high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993, blah, blah, blah. Did you see the video of her going to court? When she was going to, she had filed something at Supreme Court. I don't think I want to be seeing that of my Chief Justice going there every day to answer a matter like this. I think that it's an honorable thing to actually keep this process in the
You seem to love her more than yourself.
Look, it is not about her. It is about the integrity and the image of that office. Look at the way everybody is running around you. There's a certain dignity we must maintain, irrespective of the fact that we are calling on accountability for the office. You talk about this place.
So she should shut up. She should shut up. Even when for that protection, things are being done wrongly.
No, I haven't said that. Where is the wrong? That is these submissions I've made is supposed to put the question, where is the wrong? Okay. This particular facility, Edu Lodge, first of all, it's not a security zone. It's a facility owned by the Ministry of Foreign Affairs. And look at what Akufo-Addo, who appointed her, said when he commissioned and refurbished the place as a presidential lodge. As a presidential lodge, that's the class that you have. I don't think that the CJ is being fair to the process. She's not also being fair to us as Ghanaians. I think that we should spend a lot more time debating and questioning the case that has been leveled against her, the merit of it. But when you go through all this process, tell me, where is the human right abuse that you've gone to a place that is not
considered? Her uncle there was a planning of a murder of her uncle, and that
it is not true. Go and read this. The what you call the
isn't this traumatizing? She says she believed that this was set up. This was set up to make her feel the hurt.
Why did Kufuor, who made us put up the bust for these 3 judges? He, Kufuor, who made us put the bust, found reason to renovate that place and commission it. And these were his words. He says that today, as we reflect on this exceptional project, we celebrate not only the physical edifice before us, but also the values and legacy of a man who dedicated his life to public service and diplomacy. Why is she not talking about the fact that this is a place that is dedicated to public service and diplomacy?
Thank you. So, yes,
you say, senior.
What kind of punishment is this? This is traumatizing.
There's no trauma here.
When this thing happened,
my brother is suffering with this.
Thank you. Hold on.
The decision, I personally made an inquiry. I said, oh, why that? Then the suggestion was that different options came onto the table. First, the whole idea that the head of the judiciary will now be coming back into the building, more like, for want of better word, an accused person, for her subordinates and others, a daily hearing and others, and to preserve the office and who she is. The committee members said no. It will not be dignifying to allow her to be coming for quote-unquote subordinates and all of those to be seen here, come, go. So the decision was to look for options. Then they realized that the Edu Lodge had all the facilities that can provide the comfort to have these proceedings. And that's the choice. Whether it's right or wrong is another. But you see, what we are not permitted to do is to obviously use history and historical events to more or less mislead the public.
What do you mean?
When she says, for instance, she uses the word, the planning of the murder of the judges, Edu Lodge featured prominently. Prior to coming here, I went for the 85-page SIB report, executive summary, paragraph 9. Amatekwe and Captain Kojochikata retired, met at Edu Lodge on 31st October 1982, unquote. Guess what? The events happened on or about 30th June. By 31st October, the murders have happened. And if you read further the executive summary, it was Captain Kojochikata and Amatekwe who met in front of the Edu Lodge. Nothing more in terms of the planning and execution of the murder. So to suggest even remotely that the Edu Lodge featured prominently in the planning is misleading. And the only reason for that is politics. To play on the emotional keyboards, and obviously, you know, we are getting close to the Martyrs' Day, 30th June. Monday. So this was well orchestrated to basically do politics with this removal process. And I think that with the greatest respect to the suspended Chief Justice, that bit of it was completely untenable.
Unnecessary.
Everything about it was untenable. Hold on. And you see,
I agree that
why would Her Ladyship, the Chief Justice, now suspended, want to bring that historical matter into this? 43 years ago, an event that happened. What has that got to do?
She has been telling the public about her discomfort in going to that place. And she went to tell the court, and they say you can't bring these matters up. So she wants us to know the reason she says Edu Lodge is traumatizing. Now, Hassan.
But you see,
Hassan, have you read?
Sina, wait. You see, if she had left the conversation at the point that I don't feel comfortable with Edu Lodge. It ends the conversation.
I mean,
but when she says,
why doesn't she feel comfortable? She should say
no,
it.
no, I'm coming.
But what you
when she says
but
that,
don't lie.
You see,
but she lied.
I mean,
Yes,
if you can't be truthful, at least be accurate.
What's the place for planning?
No, but hold on. If you can't be truthful,
It is in
be
the
accurate.
special investigative board report.
And
That's
then
again,
you
the
see
planning
the
was not there.
No, but the SIB report is 85 pages. I will give you
SIB report.
Planning.
Is it
Senior, let me
it was a lie.
wrap up on this one. Senior, all that I will say is that the choice of that
have gone to commission that place.
The choice of that place was not a decision of government. It is different if President John hold on.
You say the choice was to protect her image because the processes have always been these kind of impeachments have always happened in the court premises, and you don't want her coming there for her subordinates and all the people that she superintends to be seeing her up and down. But she says, if it is about me, I make the choice. I want to be there.
That is a communication that ought to have been had between she and the committee members. Thankfully, Senior, as we speak, when her ladyship, the suspended Chief Justice, decided to set up the panel to hear Vincent Assefua's suit, was Justice Asiedu not on that panel?
Yes.
Has she ever doubted his mind? His judicial mind?
What's the point?
The point I am making is that Justice Asiedu is a member of this committee, a person that you found worthy. When there was a suit challenging your removal, you placed her on that panel, the 5-member panel.
Indeed.
So it's somebody that you have enormous respect. Would you have empaneled somebody you have no regard for? No. So if all of these are your concern, I say, my Lord Justice Palman, this particular building X a certain memory for me. Maybe let's go to the International Conference Center. Let's do this. This can be reasoned. But the point is that if you can't be truthful, at least be accurate to suggest that Edu Lodge featured prominently in the planning of the murder of the judges.
That's not correct.
I mean, it's absolutely
well, okay. So I have to go back online, but before I do that, quickly, Hassan.
Yes, sir.
I wanted to bring to your attention this particular point. If you have had the benefit of reading the SIB report, and they are referring to specific pages, because she had actually invited the public that if you want to know the source of what I mean by the Edu Lodge and it featuring prominently in the planning of the murder, go and read this report. And some people have gone to read the report, and they come, and their conclusion is that she was inaccurate, what she said. What do you know? Because the murder was in June, and the meeting reported at Edu Lodge was in October.
You see, something. This matter, the discussion should be elevated, and then we shouldn't deal with some amount of, with all due respect, palpable frivolities. First of all, I need to go back to the point about the lawyer's representation. I need to set that on record.
As we won't finish the show.
You see,
it's time. We're using time.
Okay, okay, because what I'm saying is that the people knew about the man. The first notice that was served on the Chief Justice went to her directly with no venue. Then she got the lawyer to write to them. The lawyer wrote, they now serve hearing notice on him, this time with venue. That has to be on record. Now, let's come back to the Edu Lodge. Edu Lodge, for her, invokes a certain fear, a certain, anxiety,
yes,
a certain pain.
Yeah.
And the woman cannot say that.
He can.
I mean, we have put this woman before a process that is unprecedented. She is going through a certain process. And then we are saying that we should... Is that not first of all, we say don't go to court. We say you cannot even determine where we go to have the sitting. And then we say that you can't even come and talk about it. No, you can't express your anger.
Hold on.
I mean, really and truly, what is it? We have said, for instance, that look, the plan to get the woman out has been
Hold on, 1 second.
So whatever she does,
One
even
second.
if she swims,
No, the
people say
point
she's
is
talking
that
dust.
no, Hassan, can we be faithful to the facts? Here, what did she say about Edu Lodge? What she said about Edu Lodge
she said
is that it featured prominently in the planning of the murder. Wait.
she may have gotten the sequence of events wrong.
Hassan,
But you see, I'm not here to do the bidding of the CJ.
Hassan,
what I'm saying is that we are dealing with the facts outside.
Can I moderate the show?
Please go ahead.
Prominently in the planning of the murder of her uncle.
That's right.
In June of 1981, we are told that if you read the report, which he invites the public to go and read, the specific pages where Edu Lodge features, it talks about Captain Kojo Chikata meeting, in that said meeting at Edu Lodge in October of 1982.
In front, I think.
Yes, in his car.
So not at the lodge itself.
In October of 1982. So
let's not believe what the point.
Is it important? Because some say this is very important.
See, the point I'm making is that the Chief Justice may have gotten her facts wrong, all right? And all of us are capable of getting anything wrong. You understand? So I'm not saying that she is infallible. Okay. She may have gotten it wrong. So let's walk.
No. But you see, call it a human rights violation. Me, that's my problem.
No, but she's saying that the place evokes a certain.
So is it a human rights violation? In your opinion?
Of course,
a human right.
Senor, please. You see, please let me make my points. In law, the mere fact that you are coming menacingly at somebody is enough to raise an issue of assault. You understand? So you don't even need to attack the person. So seeing some of these things is enough to let me understand that, look, there is some issue about the choice of location.
Okay, thank you.
What if so was it the only location?
Vicky, we have kept you on there for too long.
Obviously, she raised
Hassan, hold on. Hassan, hold on. Let's hear Vicky briefly, having heard from the around the table, and then I understand that Musa Ahmed has also joined us. He will also have a quick bite on what he has said so far through the press conference, and more particularly,
I think that it is wrong.
Hassan, let's stay here. And more particularly, the questions being raised that the CJ has broken the law. Any consequences? Yes, Vicky.
Well, she has, in the sense that she's gone against what the Constitution says. The consequences, if any, will also, I guess, be decided by the committee. They may decide to let it go, or they may decide to, start a course of action to address what she did. But she went outside the sanctity of the proceedings, as we've all been discussing, and addressed Ghanaians. I mean, it sounded like she wanted to put her case before the public, and for the public to be judge and jury of what is going on. I've expressed my views earlier. I'm not really in favor of that for the reasons that I gave earlier. I can understand that maybe she felt she was not being treated fairly. But look, it's a difficult procedure for anyone to go through. And the procedure is reserved for a certain class of public officer. They're all, very high public officials. And the ones who have been through it have all had to endure it. And so I don't think that there should be a special treatment because Justice, her ladyship, Justice Tokunu, is the Chief Justice. I think the article is meant to operate the same way for everybody who comes within its remit. And so this kind of special treatment, they're not doing this, they're not doing that, etc., it's not, I'm not sure she's gained the sympathy that she was intending to get from the public. How do you know? When you weigh the situation on balance, looking at the comments that are coming through so far, so it may actually have worked. And also the fact that it's been unnecessarily politicized, because every time she appears, she's got MPP people all around her. It's not helping her situation. Of course, she wants to have people who she feels comfortable with, but it actually entrenches some of the views that people hold, rightly or wrongly. I mean, I'm not saying that's wrong, right, but I'm just stating the facts as they are. And so I would wish that the unnecessary or undue politicization of this whole thing is toned down.
I've asked this question before. If the Chief Justice finds the most competent of lawyers she wants to use to be people within the NPP, what's wrong about that?
Well, as I said, she's entitled to choose who she wants to represent her. But it is unfortunate that on top of that, and if they happen to be NPP lawyers, that's fine. But when you have that juxtaposed against the minority in Parliament making a lot of noise and kind of representing her to the public and in Parliament, whether overtly or covertly, it then begins to paint a certain picture, and whether or not that's intended. I'm just saying that perception in these things matter, and right now it's being perceived as an NPP, NDC thing, and it's not. I mean, there are people who have been through this procedure, and it's been done quietly.
No Chief Justice has been through it yet.
Pardon?
Of course, she's a judge. Judges have gone through it, many judges, but she's the Chief Justice. So no Chief Justice has gone through this yet. She's the first.
Not yet, that is correct. And there always has to be a first. Before those other Superior Court justices went through it, there never had been anyone else. Before Charlotte Hussein went through it, no EC head had been removed. So there's always a first. I mean, the provision is there. And when it needs to be invoked for a particular situation, it will be invoked. I mean, if you look at the US situation, look at some of the provisions that Donald Trump, for example, is invoking. I mean, some of them have not been used in 300 years or whatever. So, I mean, the law is the law. And we must all come before it, and we must all be equal before the law. And I'd like to...
In Utaderi, the Supreme Court was forthright in saying that if you breach the confidentiality rule, you could suffer, a suit in defamation. You could suffer a suit for a declaration of the breach thereof. You could suffer criminal processes, including contempt of court. You really expect that if you and I did this, even particularly as lawyers, it's fair to expect that we will be cited for contempt. You really expect that the CJ will be cited for contempt?
Well, I mean, that is up to, if she is, then I guess she would have brought it on herself, and she would have weighed, I mean, she's the Chief Justice, she understands the law, so she would have weighed the possibility of this happening and decided that on balance, she preferred to come out and take the risk. But as we've been saying consistently throughout this, it is an ad hoc committee. There's a Supreme Court case that's establishing that, and they are free to make their own rules. So they may decide to waive it. They may decide to waive it, or they may decide to exercise it.
Exercise it and get to a court to say Justice Tokonu is in contempt. Let's put her in jail. Can you imagine that in your country?
That would be unfortunate, and it is not an outcome that anybody wants. Of course, it is not an outcome that any of us want. Especially as a woman, and especially as the Chief Justice of this land.
Okay.
But what I'm saying, that yes, she knows the risks, and she decided that on balance, because she feels so aggrieved by what is going on, it was better for her to put her case before Ghanaians. But that is her.
Thank you. Thank you. Musa Ahmed, let's hear you briefly around this. So from where you said, maybe I should ask you to begin from here. Can the committee's proceedings continue? The CJ has indicted them. She says every step of the way, every bit of anything they have done has broken the law. And she's going to continue to appear before them for the process to continue. Can you imagine that?
Good morning, Samson. Good morning.
Good morning, Senior.
Yes, Socrates once said that the law is reason free from passion. You see, so what are we looking at here? A committee has been established under Article 146, not under an act of parliament, but under the supreme law of the land. You have submitted yourself. If you complain that the committee is breaching your human rights, what does the Constitution say? If you go to Article 33,
Go to the High Court.
you go to the High Court.
She has gone to the High Court.
And you see, for me, she's not setting any good example for anybody to follow. She's a Chief Justice. She must vindicate, validate, respect, and make sure the law works in our country.
When her rights and human rights are being violated, she says every step.
You see, she only composed one-sided story for the public to hear. Did you hear the side of the committee? Did you hear the side of the committee? You don't go to the public to present an ongoing case. You are seeking to do politics. You are seeking to prejudice the outcome of the case, which to me is not constitutional. It is not lawful. It is wrongful for her to do that. That is my candid opinion. It's very wrong.
So my question is, can the process continue now? She will appear before them, her peers again, yeah?
Of course, the process was established under the Constitution. The Constitution is the highest law of the land. Nobody is above the Constitution. So what the Constitution says is what everybody must follow. Since the procedure was done under the Constitution, it must go on. One person cannot terminate the process. The process must go on. And in my opinion, it must go on and go on to the end.
So she said this. She said, I have chosen to honor the process set in place to hear the petitions, but I do not choose to hide from the nation that perversion of law, rules, and due process, as well as all as we all know it, are driving the proceedings, and this renders the proceedings unconstitutional. I choose to trust that such darkness will not totally engulf this nation. She actually said that by the manner in which they are going, witnesses are picked and chosen anyhow, documents are picked and chosen anyhow, and she doesn't even know which of the petitions they are holding, which of the responses and which of the documents she submitted they are holding. And she says that she could submit herself to the process to the end, but they could just, as it were, by some magic, whip up something somewhere and find her guilty. That's what she's saying. This process has already condemned her even before it started. You say the process can continue this way?
Thompson, she chose a convenient public forum to ventilate her perception and her side of the case. The committee, we all know, cannot also come to the public and respond to her. And she also knows that. And I believe that is why she chose the forum that she chose to go and ventilate the information that she gave out to the public. In my opinion, one party cannot decide that my interpretation of a court's proceedings or a committee's proceedings is going against the law. So I want the public to know. We need two sides of the coin. We need to see the two sides to be able to make an informed decision. I will not accept her one-sided information accusations that she made to make an informed decision on this matter.
And why shouldn't the committee speak? And why shouldn't the committee speak? They can get a spokesperson to also speak for them.
I don't believe in that, because they are working within the confines of a constitutional provision. I don't think the Constitution has provided or made any provision elsewhere that they could come out and speak before the termination or conclusion of their work. There is nothing in the law that says that. And I would even advise that they do that.
She makes a point also that it is not as if she's the first to bring these matters public, as in the content of the petitions. You know, she took us through each of the petitions and showed how they are frivolous. Some of them are actually on the basis of her immunity, and yet they are still being heard. She's saying that this is already out there in the public, so she's actually not the one who is doing it.
I think she should advance all these arguments before the committee or a court of law. As a Chief Justice, she's supposed to set a good example. You think everybody who is before a court or a committee should be doing this? We will end up having chaos. Even, sorry, excuse me my language, in the animal kingdom, the common law, they use common sense. Common sense and order prevails there. If you are not happy with proceedings of a committee that is trying you or investigating or going into allegations against you, you don't come to the public to make disparaging remarks about committee members, about the constitution of the committee, the workings of the committee. In the first place, the workings of the committee is in camera. Why do you come out to come and expose the matters there? Why don't you go to court? Are we the court of law?
What is disparaging about speaking to the facts?
For instance, she made disparaging comments about Justice Puaman.
How?
He accused him of bias when the man was not there to respond to it. Is that not disparaging? She accused him of so many things. And that was wrong. She didn't speak to the issues, in my opinion, on that issue. You see, so we should not allow parties who appear before the court, parties who appear before committees or commissions of inquiry, to come to the public and distort information for purposes of winning public sympathy. It is wrong.
She says that the senior police officer in his petition, is even citing Puaman as a potential witness. So there's conflict of interest. Is that disparaging?
That one has to be determined by an independent umpire, not herself. She can make the allegation, but she has to make it at the appropriate forum, not in the public.
This is the forum, she says. Look, she's a judge of a lawyer of over 30 years standing. She's a judge of over 20 years standing. And she says that for all her life, nobody can accuse her of having taken a bribe, not once. And she says that, listen to her, she says, so what if these current proceedings are being carefully staged to result in my removal as a Chief Justice, even if there is no lawful justification? All I have stated shows that any such actions would have been done on the basis of lies and violations of law and due process. As a career judge who has served under 4 different presidents from High Court, Court of Appeal, and Supreme Court, I could never have imagined such irregularities possible if I had not personally encountered it. I am also a mother and a grandmother who must hope for better than this for our nation. It's rule of law and democracy. It's rule of law and democracy. On my part, I choose to respect His Excellency's warrant of suspension and so on and so forth. So she's telling you that in the end, this could all be staged just to remove her willy-nilly. She's pointing to Parliament. Justice Akabuafo, there was a petition against his nomination. The parliamentarians looked at the provision of the law, plain on its face, and said the accusation you are making is about the judge's judicial duties. Those ones, you cannot bring them before us. They threw the petition out. She's saying, why is it that matters that I sat on with Puaman, with Adibu and all the rest, you are still bringing me here to answer?
You see, Samson, when matters of fact are pleaded on a document, the court or the umpire or the arbiter is not to conclude based on the matters of fact alone. The court or the umpire will decide the matters based on evidence.
Right.
So have they finished with the proceedings? Have they finished with taking evidence? Has she presented her evidence in her defense? What she is doing, what she has done, and what she continues to do, is it sanctioned by any law? You can talk about free speech, but when you are before a committee or you are before a court, do you have the right to come out and preempt and prejudice the outcome of the case before the court? Do you do that? Are you allowed to do that?
Can you imagine?
Talking about bribery and corruption, has she been charged with any form of corruption or bribery?
Because she says nobody can ever accuse her of one.
Yes, but that will not deflect from the fact that you have abused your office.
But how is that even corruption?
You see, when you have abused your office, when you have misconducted yourself in an office and an allegation has been made against you and there is an ongoing proceedings, I think you should exercise patience. Present your defense.
So
present all the defenses.
Finally, Musa, she's raising some important matter. She says that this group, by name Shining Stars, one of the petitioners is a group. The name is Shining Stars.
Yes.
She says they have checked at the Registrar General. That group is not known to have registered as any entity.
It's not a fair legal point before the proceedings.
Is it not a point to make?
No, but capacity.
You see, Samson, please. You see, this is a matter that she has come to tell us. Okay? And has the committee ruled on it? Has she presented an argument before the committee? And has the committee deliberated on that issue and come to a definitive conclusion for her to come to the public to seek justice? This is her own side of the matter. I think we should take our time to respect the law. We should respect the Constitution. We should respect the proceedings until the outcome.
Okay. Senior Musa Ahmed, thank you very much. She says it should be inquisitorial rather than adversarial. I wrote an article in 2018 after I led the process in the removal of Loretta Lamte. Not the Supreme Court, that's Charlotte Osei representing Kokubako. And I remember there were situations where I had to urge on the committee. Justice Eniyewa was chairing it, Justice Benin were there, Mariama Owusu. And I had to urge them that they should take an inquisitorial posture rather than adversarial, like prove your case or walk out. And we had actually obtained certain evidences, and then the source of the custody of our evidence was being questioned. And they were trying to rule some of them out, that we didn't get them from proper custody. And we're insisting that we're actually helping them. They should be inquisitorial. They should go and help find these things. Is it not right that it should be inquisitorial rather than adversarial?
That is why I'm saying that for me, she has only come to give one-sided part of the case to the public. I'm not going to accept that until I have read the full ruling of the committee or the committee's report. I'm not going to accept that. You see, a party should not be coming to the public to determine how a procedure should be formulated. In fact, if you are before the court, the judge is not even bound to accept the submission of counsel as to how the proceedings should be conducted. That is the law. You don't go and impose your own view of how the procedure should be conducted to a court to accept it. It doesn't work like that.
Petitioners are being allowed not to testify, so they choose witnesses. She must be worried.
But do we have this information ourselves? Do we have this information ourselves? When you read the entire statement she made, the formulation she made about Edu Lodge has been debunked. So how do you know that the other legs of the allegations she made are true?
Imagine it were true that the witnesses.
I will not imagine anything in law.
At least we are discussing on the presumption that what she's saying is true. We can't.
You see, she's entitled to justice. Yes. I agree with you. She's entitled to justice, fairness. If indeed the committee is abusing her right, I will not say they are doing it. If it is true that they are abusing her right, then I will urge them to conform to the law.
If she hadn't told you, how will you be urging them to conform to the law?
Well, that's why I'm saying that the committee is just like a court. It's not different from the court. You may be looking at it from other principles, but essentially, it is not a different version of a court.
Okay.
Yes, and she has to present her case there. She cannot come to other third parties.
Thank you.
Anybody, you see, if the case was going well for her, would she come and complain?
Musa Ahmed, thank you very much. And this is the first time I'm hearing Musa Ahmed speak in this way. Well, thank you for joining us. I'm going to take just 2 minutes. I'm going to hold all of you to it. 2 minutes each, and we are done. Don't complain about time. Hassan, don't complain about time. We are not going to take that argument. Listen,
who have taken a position against this? I probably have taken a position.
You are entitled to your position.
With the position, but
no. Are you here for this?
But I'm not. But I see. I have some argument.
We are wasting the time already. 2 minutes each. No, I'm going to start from Senyo.
Yeah. One, I don't see the human rights violations that she's citing, save for the issue about the petition. She's entitled to it. I don't think it is fair that a committee, if true, can presume that because the president extended that to it, what it has, no, I think we should respect that.
Okay.
The other thing is that the CJ, her conduct is not fair. And I repeat, it's very irresponsible. She knows the law. And besides that, you are throwing the committee into a ring with their hands tied to their back. We all know that the committee will be responsible enough to comply with 146 and not come out and speak. It is not just from a Chief Justice. It is not fair from a Chief Justice, and it's also not responsible from a Chief Justice. I think that she needs to surround herself with better counsel. This matter is not supposed to be prosecuted in public.
You are indicting her counsel.
Her conduct is indictable. She called it onto herself.
Aikoto is a former attorney general.
I respect.
He has sufficient political experience.
And he's a good friend of mine.
But the press statement was not read by Aikoto.
He knows. Aikoto knows.
He prepared it.
Aikoto knows that he will not sign up to this kind of conduct. You should know the standards of Aikoto. I'll be very, very disappointed.
She will not be going for better lawyers. Aikoto is a far better lawyer.
She's a great lawyer. He's a great lawyer. Aikoto is a great lawyer. But this conduct is not coming from good counsel. When I say counsel, I'm not talking about lawyers. I'm talking about advisors, the people she's surrounding herself.
Okay, thank you.
That's what I meant by counsel.
Thank you. Hassan.
Senior, you see, the issue before us, like I said, is a premeditated one.
Aye.
It's a premeditated one, and I keep saying it, and you have to allow me to say it. Okay, during the electioneering campaign, we were told that this Chief Justice is not fit for purpose. In fact, we were told that they are going to purge the judiciary. All right? They are going to purge the judiciary, and it starts from the top. So everything has to be done in order to actualize this determined, conclusion. You see, we go to, for instance, Article 1468. All proceedings under this article shall be held in camera. Does in camera mean you can't take your spouse? In camera means that you can't hold a meeting in public. It shouldn't be aired in public so that the public should not know. But it doesn't say that I can't take my bodyguard, I can't take my spouse, I can't take my child. It doesn't say that.
But see,
even Article 146, Does it say there should be prima facie determination for the Chief Justice?
Hassan.
It doesn't.
Hassan.
But you see,
Hassan.
but the Supreme Court has read it into the Constitution to say that you can't have a prima facie.
You compel me to ask you a question. You compel me to ask you a question.
Yes, sir.
As practitioners of the court,
yes.
If you were going for a divorce matter, for example, who will the judges allow into the chambers, or who will the judges allow in the courtroom? They will clear everybody, leave only the parties and their lawyers, correct?
That is correct.
If they came with friends, would they allow the friends in?
Oh, that one, the parties will also, they will have to raise objection. If they don't raise objection, you can sit in.
No, it's not parties. What would the judge say? The judge will say, if you are going to the judges' chamber, you say only the parties and the lawyers. Finish.
See, I have done divorce cases. I have done divorce cases, for instance, where other parties have accompanied the parties.
Okay.
All right. They were there in court. There was nothing wrong with it.
The judge
because
allowed
you see,
it. Okay.
The matrimonial cases will be reported anyway. You understand? This matter is not going to be reported. You understand? So the contest. No, this matter. Why is it going to be reported in the law report? I'm saying that whatever happens at the matrimonial courts is going to feature in the law report. They will report it, so you know what.
Let's say it's a bad example I use. Go ahead with your submission.
So what I'm saying is that this provision cannot be interpreted to mean that you can't walk in with third parties, because it is supposed to mean that we want to preserve the integrity of the judiciary so that things that happen in the place are not thrown out in the public domain.
Will the third party swear an oath not to disclose the matters?
If they want to put the committee will determine their own procedure. If they want the third parties to sue, why not? But what I'm saying is that you are saying that the committee will determine their own procedures, isn't it? And I'm saying that this in-camera meeting is not supposed to be interpreted to mean that you don't come in with third parties. That is the second thing. In fact, the level of affinity or consanguinity should also determine who comes in. You understand? So if I have 10 lawyers, are you telling me that all the 10 lawyers cannot come in? I'm entitled to only one lawyer. So you see, let's be liberal about the interpretation that we give to this Constitution. And I've said that in Ajechum. Article 146 does not provide for a prima facie determination for the Chief Justice, but they read it into the Constitution. You can have a prima facie of a Justice of the Supreme Court, but you are silent about the Chief Justice. So the Supreme Court read it into it. And I'm saying the Supreme Court missed an excellent opportunity to have read something into this. Because if you appear before a committee set up under Article 46, and then the procedure is so badly flawed, and it says that under Article 1469, the President shall act in each case in accordance with the recommendations of the committee. So the President's hands are tied. The person against whom the petition is made is also not, capable of doing anything. So you can't do your status bad, more or less.
Thank you.
But I'm saying that so it is only in the course of the proceedings that you should be able to raise issues. Now you're saying that if I raise issue problem, I go to the Supreme Court problem, I go to the media problems. Everywhere I go problem. I mean, equity shall not suffer a wrong without a remedy.
Thank you, Edu. Yes, Edu.
President John Dramani Mahama so far has demonstrated utmost fidelity to the laws of this country. It's curious. President Mahama took the oath of office administered by her ladyship Gertrude Tokono.
And now she wants him out.
Please hold on.
And now he wants her out.
Please.
Oh, he hasn't petitioned anybody. The president hasn't petitioned anybody, even though he's spirit.
Hold on, please. In the oath administered, it was like read after me. President Mahama read after her. That I shall uphold the Constitution. Again, she repeated that if you don't, the consequences includes your removal from office as the president. Now she invites the president to do that which the Constitution does not permit. So as to do what? So clearly, President Mahama, having been properly advised, has limited his conduct in this matter to what the Constitution says. I've heard others make the suggestion that, after 32 years, can we work on the constitutional provision? That's for the Professor H. Kwesi Prempeh Committee to do. That is not for President Mahama to sit in the comfort of his office and say, I like this provision of the Constitution, I don't like, I will apply this, I will not. But you see, I think we also need to make this point clear, The 1968-1979 constitutions, if you read on removal of justice, never had an in-camera provision. It was open to everyone. And that is why, if you notice, there was an attempt to remove Apalu through parliamentary proceeding. Yeah. That was cured by Tufo and Attorney General.
Yeah.
In 1992, with the benefit of hindsight, the framers introduced the in-camera proceeding to cure a historical wrong, so that matters of this nature will be had in a situation that preserves the integrity and independence of the judiciary. Away from this invitation, that now, because it is here, we should do otherwise. I think that we must not allow that view to stand. Two, I strongly believe that President Mahama is in a situation where nobody wants to be. Look, and you even led the prosecution of Loretta Lamptey. It was under President Mahama, appointed by President Mills. However, when your client, Richie Nyama and Frank Anodompe and Co. brought the petition for her removal, President Mahama didn't say that because my boss, President Mills, appointed her as Strat boss, I would decline the invitation. He complied with the Constitution. Not only that, subsequently in January 2015, President Mahama suspended her. How different is what is happening today? So, like Pontius Pilate, President Mahama is put in a situation where he has to take a decision. Thankfully, the Constitution says that take that decision without referring the matter to the governor in Judea. So he said, bring the Council of State involved in the matter. That has been done. Must the prima facie decision be reasoned? I mean, there are, plethora of Supreme Court decisions as to. In fact, the Supreme Court in Michael Asamoah and the Republic appears to take the view that even after lawyers, the Attorney General says, we have closed our case. In fact, the judge is permitted right and then say, look, open your defense. Okay. Without reason, ruling or what have you.
You have also done more than 2 minutes.
Yes, but at this point, all that I want to say, maybe in conclusion, is that, first of all, the Chief Justice had the benefit of responding to a petition. Correct. It is also not the law that when evidence is to be taken, the petition ought to be tendered in evidence. Do you tender your writ in evidence?
Why are you asking me that question? Ask Hassan.
If I had made said proposition before her ladyship sitting, should I say, Edu, where did you do your pupillage or something? Because you don't tender the petition or the writ in evidence. That is what invokes the jurisdiction.
There's something
at this point, all that I have to say is that, look, let the sanctity of the process be respected.
Thank you.
But something, there's something we are missing. She said something which is very important. She talked about her security. She talked about threats.
Threats of harm.
Of harm. We can't take that lightly. But the big question must go to her. Has she reported it? Do we have investigations commenced into that particular matter? Okay. We must put that out, because if you come and you just throw this, and you're a Chief Justice, have you actually submitted it? Have you filed?
Maybe she has.
Yeah, she should have told us. I think that we should make further inquiry into that, because her security is something of optimum interest for all of us as a people.
Thank you very much. Thank you.
Hold on. Thank you. I want some learning from you. CMCs, even as CMCs, are parties permitted to bring spouses, even as CMCs?
Thank you. I'm sorry. We need to go with the time. Thank you.
You don't
sorry, gentlemen. I'm reading a portion of a statement to conclude. But I would say that having led these processes before, I think it is neater that when a prima facie is made, there is a substantive ruling on the prima facie and shared with the respondents. In my case, a prima facie was done about how many pages, and was shown to me that these charges have been thrown out, these charges remain. But again, once again, gentlemen, some of the Chief Justices don't actually believe in inviting you to bring a response before they do a prima facie and so on and so forth. So it's people and their style. Now, she ends by saying, and I remember disclosure, my own station, multimedia, they didn't like me at the time because they would call to say, want to know what happened today? And I say, it's in camera, I can't share with you. Interestingly, she says, there have been some recent suggestions about rules being made to safeguard judges from frivolous attempts to remove them from office. This has been going on in Parliament. He says, it sounds like an attempt to assure the judiciary that after unconstitutional and illegal means have been used to remove me, conditions will be made safer for those who help with it, or those who may feel afraid by the current occurrences. Despite the interesting new discussions of rules for removing judges, I am convinced that it is only a matter of time for the nation's democracy to experience the bitter harvest of what I am reporting on. We'll be right back.